Mr. Speaker, this bill makes significant changes to 17 of our criminal statutes. Overall, I'm supportive of the bill. I wish to speak today on two matters that I find most significant. First, on tackling scams. Second, on the reduction in the use of caning for other offences. I also have some queries on the new offence of doxing of public servants. My party colleague, Member Fadli Fauzi, will speak later on related issues and other aspects of the bill. First, on tackling scams. It is clear that despite significant efforts poured into anti-scam measures, Singaporeans are still falling prey to scams and losing significant sums. Banks have made efforts to strengthen digital banking to detect and delay unusual transactions. Public education has intensified. There is now even an anti-scam warning on the Parliament website. But scammers too have raised their game. Scam organizations are brilliant at social engineering and tailoring their ruses to suit the intended victim. Scammers are going further. In one case I came across, the scammers even coached the victim as to what to tell police if she was questioned, which she dutifully complied with as if under some sort of spell. Clearly, we are dealing with highly sophisticated operators. So the bill has 19 provisions that are targeted at scam offences. Although there are existing laws to cover these situations, the new provisions create new specific offences or enhance the punishment if they are committed through scams. For instance, the Organised Crime Act is being amended to create two new offences of being a member of a locally linked organised scam group and being a recruiter for organised scam groups, whether locally linked or not. Besides setting high fines and jail time of up to 5 years, mandatory caning of at least 6 strokes is to be imposed. How effective the provisions will be will depend on how tightly they can be enforced. No point having strict laws if offenders are not pursued. It is also likely that even if persons are caught, offender displacement will occur, meaning that there will be no shortage of persons willing to replace them if the rewards are lucrative enough. For organised scams, effective enforcement will require agencies across borders to share information and conduct joint operations as well. At this point, it is not clear to me how committed every government in Southeast Asia is towards combating scams. In the past week, there was extensive media coverage on a scam ring in Cambodia, apparently led by a Singaporean and staffed by scores of compatriots. It was reported that the Cambodian police conducted a joint operation with Singapore police on 9 September, after which 15 suspects, including 12 Singaporeans, were arrested and charged here. It was further reported that Cambodian police found evidence of the involvement of other suspects, and this evidence formed the basis for the SPF to issue Interpol red notices against them. While the handling of this case so far shows strong cross-border cooperation, I wonder if such extensive cooperation happens on a regular basis. Further, does the Ministry expect in future to utilize the expanded powers under the Extradition Act to request ASEAN neighbours to hand over such suspects to Singapore through extradition? So it is public knowledge that Southeast Asia is a hotbed for organised scam groups, and some ASEAN countries are reported to be where the main operations are located. To respond to this, some governments are using other tools besides the criminal law. 2 months ago, the American Secretary of State, Marco Rubio, issued a statement highlighting that criminal actors across Southeast Asia had, and I quote, increasingly exploited the vulnerabilities of Americans online, unquote, resulting in an estimated loss of $10 billion last year. He announced that the American government would impose sanctions on various persons and entities involved in running a scam center in Myanmar and forced labor compounds in Cambodia. He opined that such sanctions would have the effect of disrupting the ability of criminal networks to perpetrate their fraudulent and abusive activities. To that end, it would be useful to know to what extent the Singapore government will also consider other tools outside the criminal law to disrupt such organised scam groups. The bill also introduces caning as an additional option in scam cases involving the misuse of SingPass credentials under the Computer Misuse Act. The same is being done under the Miscellaneous Amendments Act for scams involving the misuse of SIM cards. As for cheating under the Penal Code, there will be mandatory caning if done through remote communications, such as the internet, telephone, or electronic or other technology. So the most significant aspect of all the scam-related amendments is the introduction of caning as a punishment. Given the tremendous material loss and psychological harm caused to scam victims, I have little sympathy for those who perpetrate these cruel acts. That said, the sentence of caning is a harsh punishment. While it is a legacy of our colonial past, it is a punishment where the state inflicts violence and physical pain on a prisoner. From reported accounts of some who underwent the punishment, caning led them to bleed and, by some accounts, to suffer such pain that it led them to go into a state of shock. So I accept that there is a strong imperative to curb scams, and it could well be at the stage now when we have to pull out all the stops. In that light, could the ministry elaborate on why it has assessed that caning will be effective to reduce scam activity? Did the ministry consider alternatives, such as providing for longer jail terms and heavier fines? This brings me to my second point, which is related. I strongly welcome the reduction in the use of caning for other offences. The bill proposes a total removal of caning as a punishment for certain offences, and for others, making caning optional instead of mandatory. In its press release on 14 October, the ministry stated that it made these moves considering factors such as whether the offences were still of significant public concern and whether other punishments sufficed. This review, to remove unnecessary punishments, brings important balance to this bill. The amendments proposed to the Vandalism Act are particularly significant and welcome. The bill removes the rigidity of the current Act, where mandatory caning of between 3 to 8 strokes must be imposed on vandalism of both public and private property, except in limited circumstances. The bill instead proposes that mandatory caning be removed for all vandalism offences. Instead, caning will exist as an option for the court in cases where the vandalism is deemed more serious. So even after the bill is passed, I hope the government will, from time to time, review offences which currently attract caning to see if caning is still warranted. Social conditions change over time, and our laws should be fit for purpose. Singapore is currently on a short list of about 30 countries that still have corporal punishment on its criminal statutes. Of course, we must decide for ourselves what is appropriate for our criminal justice system. That said, I believe Singaporeans will support a criminal justice system that is effective and at the same time humane. Finally, doxing of public servants. Clause 25 creates a new offence in the Miscellaneous Offences Act of doxing of public servants. Under the proposed Section 14E, it will be an offence for anyone to publish identity information and false statements about public servants if connected to the discharge of their duties. I have 3 questions related to this. First, the section will apply to protect public servants. As to who would be considered a public servant, the proposed definition refers to the definition of public servant in the Penal Code, as well as any person who, under other written laws, is deemed a public servant for the purposes of the Penal Code. If so, would someone holding a political position, such as a minister or member of parliament, be covered under the section? Second, the section prohibits the publication of identity information not just about the public servant, but also a related person. The definition of related person is stated as another person about whose safety or well-being the public servant would reasonably be expected to be seriously concerned. This definition is inexact and potentially includes almost everyone, including family members, colleagues, and acquaintances. What is the intended ambit of the definition of related person? So the third query relates to the use of illustrations to clarify the law. There is an illustration clarifying that the doxing offence would be made out where the false statement and the identity information were carried in 2 separate online posts. However, this illustration is found in the explanatory statement to the bill and is not part of the text of the law. I would like to know why the illustration is not legislated together with Section 14E, but instead is relegated to the explanatory statement. It would seem to me to be more appropriate to carry the illustration up front in the law itself to make it clearly visible to anyone looking up the law in the future. Instead, having it in the explanatory statement makes it harder to locate and may lead to unnecessary arguments down the road. So let me conclude. The bill confronts us with decisions about the use of caning as a judicial punishment. In view of the devastating harms scammers have caused and continue to cause to Singaporean families, I believe the public supports the amendments regarding scam offences. At the same time, there is a concerted effort in the bill to remove or reduce the use of caning for various other offences. This is a move I fully endorse as we work to scope our criminal laws more tightly and appropriately. Finally, I look forward to the answers to the questions I've posed regarding regional cooperation and other approaches to disrupt scam organizations and on the offence of doxing of public servants. Thank you, sir.
Dr. Wan Rizal and Ms. Sylvia Lim had questions regarding the scope of the new offence. Dr. Wan Rizal asked if the new offence would extend to public service workers who perform public duties but are not public servants. The new offence will only cover public servants. False statements against public servants can directly undermine confidence in our public institutions and so warrant a higher penalty. That said, doxing of a public service worker is already an offence under the Protection from Harassment Act, and that carries enhanced penalties. Ms. Lim asked if the new offence would extend to politicians such as ministers and MPs. Political office holders are covered as they are part of the executive. MPs are currently not covered, but MHA is separately reviewing this. To be clear, persons who harass MPs are nonetheless still liable for an offence under the Protection from Harassment Act or other offences like criminal intimidation and criminal defamation, depending on the facts of the case. Ms. Lim asked if the definition of a related person of a public servant could be made more precise. A related person of a public servant is defined as a person whose safety or well-being the public servant would reasonably be expected to be seriously concerned about. The rationale for extending the offence to cover doxing of related persons of a public servant is because offenders may target persons close to a public servant to get to the public servant. The question of whether a person falls within the definition of a related person is an objective one that the courts will determine based on the facts of the case. The concept of a related person is not new and already exists within POHA. Ms. Lim asked about the placement of the illustration in the explanatory note instead of within the provision. We assess that the provision is clear enough. Not all offence provisions need to have illustrations. In any case, the explanatory note is available in the public domain and can be referred to by all stakeholders, including council and courts if necessary.
Thank you, sir. I have one clarification for the Senior Minister of State. Earlier, she mentioned Operation Frontier Plus, which is supposed to be a cross-border collaboration across jurisdictions for joint intel sharing as well as joint ops. My question is that she mentioned there are 13 countries currently on the jurisdictions under the platform. For the recent joint operation with Cambodia in September, which I mentioned in my speech, it was not mentioned that it's under Frontier Plus. So does this mean that Cambodia has actually not signed on to Frontier Plus?
At the moment, Cambodia is not part of Frontier Plus. However, we have both plurilateral as well as bilateral means of engaging our counterparts. So even as we expand networks with different jurisdictions, it also doesn't prevent us from working bilaterally with them.